I'm going to go to my colleague, Sipho Sturman, who's standing by to find out what the lawyer has said and more. Sipho, we're crossing to you. Can you hear us?
All right. All right, I can hear you. I'm sorry, we're speaking to the Public Protector's spokesperson. It's a bit of a messy situation.
Your reaction?
Well, I think this was a very extensive judgment. I think it runs into around 100 pages. So what will not be advisable for the Public Protector to do at this point in time is to offer a knee-jerk reaction. I think it will be proper for her to rally her legal team and study the ruling, understand it, especially the reasoning behind what the full bench said here today. And then at that point, she will be in a position to opine substantively on the judgment as well as indicate what the next step for her will be.
Essentially, it was a clean sweep for the president on all key points that were argued here. The Public Protector has lost, and this is yet another high-profile court matter that the Public Protector has lost. What's going on there?
Well, as I said, she will have to, go through the judgment with a fine tooth comb to understand the reasoning, because she thought that her counsel representing her a month ago put her case in a very strong manner. She wasn't anticipating this kind of a ruling, but as I said, she will indicate whether she will take any steps going forward with regard to this matter. But obviously, it's a disappointing judgment, and she respects the judiciary as well as the judiciary's authority to make this kind of rulings. But of course, respecting a ruling does not mean you must agree with it. You can hold a different view, and you have all these other avenues to explore with the view to possibly arriving at a different conclusion. But I'm not saying she's going to appeal, because she hasn't taken that decision yet. That decision can only be taken after a thorough study of the judgment.
How can the Public Protector believe that attorneys made a strong case when they were criticized, the arguments were criticized so extensively in this judgment?
Well, it would be, of course, based on previous authorities. This very same court has previously made, similar, or has made rulings on a similar case. For instance, if you look at the state capture judgment, you will see that in the remedial action, the executive was directed to take certain steps to establish a commission, to appoint a chairperson. You will notice that there were certain things in that report that were referred to the NPA. You will also notice that Parliament was directed to do something, and that was to review the Act, the Executive Members Ethics Act. And that matter was brought before this court, and this court ruled that that remedial action was sound. And that was the basis of some of the Public Protector's decision and the arguments advanced by counsel. But obviously the court viewed those differently, which is why I'm saying the Public Protector will have to rally her legal team and give themselves time to study it thoroughly and then map the way forward.
Opa, this is the latest court to question the Public Protector's partiality, to signify or to determine that she doesn't seem to have a basic grasp of the law. She confused the law on money laundering with that of corruption. She didn't seem to have an open mind, the court found. This is like the fourth or fifth very, very damning ruling made against her. In light of all these things, in light of the fact that these courts continuously raise issues of her competence, does she believe she's going to be able to stay in office if there is an inquiry into her fitness?
Yes, she does, because she does not believe that the reason for one to stay in office must be based on the merits of her investigations or even the arguments she brings before court. Because if that was the case, then even judges would stay on the bench would be threatened, because courts criticize even judges time and again to say, you were unreasonable here, you misapplied the law here, and so forth. So if that has never happened to anyone sitting on the bench, why then should it happen to a Public Protector? That's her position on the matter.
Does she believe she'll be able to block this inquiry from happening when she goes to court next week?
That is another misunderstanding. The Public Protector has no interest in blocking the hearing.
Yes.
She has questioned the rules She is on advice that the rules are unlawful and unconstitutional. So once that question has been addressed, she's happy to participate in the inquiry. She has no qualms with the inquiry. She understands that in terms of Section 194 of the Constitution, Parliament has that power to hold her to account in that way. And she has no beef with that whatsoever. Her problem is that the rules, as she has been advised by counsel, are invalid, null and void. And that's the argument she will be advancing before court. And then once that matter has been settled, then the inquiry can proceed.
Does the public protector, as we stand, do you think she still has any sort of a form of credibility? And can the public still trust her when we are seeing that it's the Absa Bank Op case, we had the Estina Dairy Farm matter, and now we have another high-profile Bosasa matter, all reviewed and set aside? How can the public continue to trust a public protector that seems to be losing on key investigation that she issues?
Well, I think the question you should be asking is whether, if this matter was decided by a court and a senior court found that the findings were irrational, would you say then that the court has no credibility? It doesn't work like that. That's why I've been saying you cannot say a person is incompetent on the merits of the case that she has advanced. If you say that, then you should be prepared to say it in respect of the courts. There are a lot of high court judgments that get overturned by the Supreme Court of Appeal and the Constitutional Court. So it can be that when a court decides that there has been a misreading of the law here, irrationality here, therefore the person is not fit to hold office. There have been public protectors before who have had their decisions set aside on the grounds of irrationality, misreading of the law, and so forth. So let's not have one set of rules for some people and a different set of rules for the others. Thank you.
Opa Sohale from the Public Protector's Office, just giving some feedback, of course, saying that at this point in time it's not clear if the Public Protector will appeal, but saying that these adverse findings are not a reflection on her competence, and that we should not be talking about issues of the Public Protector possibly resigning. But certainly it was a clean sweep for President Cyril Ramaphosa here on all points. He won this matter. The court had found that he had not deliberately misled Parliament, and that he had not violated the Executive Ethics Code, and that there was no case or a suspicion of money laundering whatsoever, and saying that the Public Protector seems to have confused the law, or seems to have a lack of understanding of the law in the manner that she applied herself in this investigation, and also found that she had no authority to investigate the CR17 campaign, saying that it was a private matter and it did not relate to matters of state affairs, and that the president did not benefit personally from this campaign. So it can be said that the president benefited, and so the Public Protector had no jurisdiction whatsoever to investigate this matter.
Thanks very much, Sipho, for that report.